All right, I'm Tom Reed, REID. I'm the Deputy Rockingham County Attorney. With me is Michael Zaino, Z-A-I-N-O, Assistant County Attorney. We're both handling this case.
Okay, Tom, what happened in today's proceedings?
This morning we were just scheduled for an arraignment, and both Linscott and Dow waived formal arraignment. Bail has been continued by the court, or set by the court, as previously said. It's $500,000 cash or corporate surety, and concurrent with all the charges that the defendant was previously facing.
Now, this was an arraignment on witness tampering charges, is that correct? What was today's arraignment for?
Yeah, and we both talked to you at the prior bail hearing that there was information that we had, which did result in 2 indictments and a misdemeanor level information being filed, alleging that Mr. Dow had witness tampered. And this is during an investigative stage when DCYF was concerned that the child was in danger, and DCYF was scheduled to come to the house to meet with the family and with the child. It's alleged that Mr. Dow coached the child and encouraged the child to lie or misrepresent or withhold information.
This was obviously before they fled to Florida.
This is before the child suffered the more serious injuries. And had DCYF been able to get accurate information at that time, it's our position that perhaps the child wouldn't have been so injured.
And that coaching was on video? They taped it? Or?
One of the allegations is that there was an unlawful intercept, meaning the defendant hid a recording device for the meeting with DCYF, having been instructed that the meeting could not be recorded. Recorded that, and during a forensic search of his computer, that video was found.
Why would they have recorded that?
Pardon me?
Why would they have taped that?
That's a fine question.
And Tom, where are you in negotiations with her as far as testimony against him?
We are proceeding with both cases based on the evidence, and the attorneys for the defendants are having the opportunity to review all the investigative reports, including the reports related to the new charges. And if and when either of them want to take responsibility for their conduct, we'll talk to them about what we think an appropriate sentence might be.
At the last one, you said that originally, their trial dates were scheduled April, June, but there was a possibility that these new charges might push those back. Where are we on those?
Well, in any case, when you continue to do investigation and find things on computers or in other sources, you produce additional information, which we call discovery. And as the defense attorneys get additional discovery, very often they want additional time to prepare. So we anticipated that with the ongoing investigation, what we knew was coming, that it was likely the defense would want to continue the case. And in fact, Mr. Dow's attorney has filed a motion to continue, and his trial date likely will be continued to later in the summer. Is that correct?
It hasn't been filed yet, but it's the draft as well.
All right. So we've been talking about that.
Yeah.
Now, the tampering, that leads me to think that the abuse of the child was long-term. This wasn't like a rash, one-time thing. There was signs of long-term abuse here.
Well, all I can talk about are the allegations, the charges that have been filed. But clearly within the witness tampering charge, we're alleging that the defendant was aware that DCYF was coming to the home, that there were concerns that they had commenced an investigation into that household and the safety of the child, and that Mr. Dow took steps to coach a child, to encourage a child, to demand that a child withhold information that may have protected the child if the child had been in danger at that time.
Thank you very much, Tom.